I would like to warmly welcome you and thank you for taking time out in the midst of COVID and everything else going on to join us for this special occasion. My name is Adironke Adebanjo, and I'll be your host today, just making sure that we get through proceedings as quickly as possible. Now, as you will hear throughout the course of the day, the Electricity Law Report is the first of its kind. You've probably heard that many times on the video that you've watched. It's your definitive source of judicial decisions in the electricity sector, as you can see up there as well. And you'll hear about all the different components of the reports today. Like we said, it's unparalleled, it's the first of its kind, and it's for everyone. That's the beauty of this report. It's for everyone, it's for consumers, it's for legal practitioners, it's for investors, it's for industry stakeholders, it's for everyone. And you'll be hearing so much more about it today. So welcome, and thank you for being here. We're going to try and keep the session very short and sweet. So without further ado, we do have the president of the MBA, Mr. Olumide Akpata, but he'll be joining us virtually. But let me just read his profile very quickly. Mr. Olumide Akpata is the president of the Nigerian Bar Association and a partner in the corporate and... Okay, I can't read this person's handwriting, so bear with me. He's a legal practitioner. He's a senior partner and head of corporate and commercial practice group at Templars Law Firm in Nigeria. He became the first non-SAN president of the Nigerian Bar Association in July 2020. Ladies and gentlemen, he is also, or has served as the vice chairman of the International Bar Association, the African Regional Forum, and he's a legal practitioner par excellence. Please put your hands together, if you will, for Mr. Olumide Akpata, who will be joining us virtually. Oh, we can do so much better than that, ladies and gentlemen. Thank you.
Thank you very much. Let me just say very quickly that I want to very quickly say how unhappy I am that I cannot be there with you physically, because that was the plan, and I had given my commitment to the editor-in-chief, Mr. Irukosu, and I'm so sorry that unfortunately we had to have a national officers meeting of the NBA, which is taking place in a few minutes here in Abuja, and so which is why I've had to do this virtually. Having said that, I'm really glad to be here with you all, chairman of the occasion, chairman of the editorial board, Chief Bolaji Ayoinde, senior advocate of Nigeria, and other members of the editorial board, and of course the editor-in-chief, Mr. Wale Irukosu. I'm really grateful for the opportunity to be here to give these remarks on the occasion of the launch of the Electricity Law Reports. I have a speech, a prepared speech. If you would permit me, I would read. It gives me great pleasure and honor to be given the opportunity to welcome us to this well-timed occasion for the presentation of the Electricity Law Reports. The subject of electricity, like that of corruption, is unfortunately one that has dominated public discourse in this country for as long as I can remember. From the days of the Electricity Corporation of Nigeria through the days of National Electricity Power Authority, NEPA, which some members of the younger generation mischievously referred to as never expect power always, and the power holding company, to today's array of distribution companies, generation companies, and the like. We are all still grappling with the challenge of having a reliable electricity sector. Only recently, the upward review of electricity tariffs, which was meant to eliminate the electricity subsidies that government pays to generation companies, GENCOs, caused such an uproar from the vocal local labor unions that ultimately impelled the NERC to suspend the implementation of the review for 2 weeks. I will be dishonest if I fail to admit that our electricity sector is still a huge work in progress. And I say this because in my own line of practice, I've also been very involved in this sector. And I can tell you firsthand that there's still so much work to do. Having been one of those who partook in the process of disaggregating the power sector and privatizing the sector, it really pains me personally to say 20 years down the line, things are still in such an untidy state of affairs. Amid the lingering dissatisfaction, however, changes have been made to the legal framework of the electricity sector at a policy and legislative level in the past 15 or so years, as part of the efforts to optimize this all-important sector. With the privatization policy and the Electricity Sector Power Reform Act that arrived in 2005. The legal framework for the electricity sector today is far more mature and sophisticated than what was obtainable in the past several decades before 2005. And it behoves on lawyers to keep up with these developments, because the more sophisticated the sector becomes, the more the need for specialists and dare I say, modestly expensive legal expertise to service the businesses that play in the sector. The Nigerian Bar Association, which I represent, certainly aspires to have a legal profession where players in each sector of our economy will be spoiled for choice regarding quality legal advice and counsel. Against the above background, it is deeply satisfying to know that we now have a dedicated law reporting of decisions that relate to the electricity sector, and that we have the distinguished privilege of being here to usher in these law reports. Even though I left courtroom practice decades ago, the sheer number of judicial divisions of the Court of Appeal, to say nothing of the avalanche of cases that roll through our courts at all levels each year, is enough to tell me that searching for decisions pertaining to the electricity sector is, in our generalist law reports, will be a daunting task. Indeed, it seems practically impossible that a generalist law report would capture most of the decisions that relate to the sector because of the competing need to include decisions on other areas of the law. Thus, the electricity law reports that we present and celebrate today is bound to alleviate the burden on the electricity sector lawyer and enhance his or her research efficiency and effectiveness significantly. This is a very commendable achievement and a sure step in the right direction. Let me also use the opportunity to say that there is an obligation on lawyers, law report publishers, and the MBA as our umbrella body to pay close attention to law reporting in Nigeria from a quality control perspective. It is an area in which the current leadership of the MBA has resolved to step up its vigilance. As lawyers, we are known for settling for nothing but the highest professional standards. And so we expect that the electricity law reports will meet and sustain international standards of law reporting in both its content and setup. I am confident that the publishers will not disappoint our expectations. Indeed, I have noted that Chief Ayoinde is chair of the editorial committee, and I know that he's very passionate about this issue of quality control or standard control in law reporting. So I know that electricity law report will definitely pass muster in all of its iterations. Along with the presentation of the electricity law reports, we will also be engaged today by a seminar discourse among experts and stakeholders in the electricity sector on how to make the sector privatization work as we hoped and continue to hope that it would. I believe that listening to the thoughts of our distinguished discussants, as well as their answers to the questions that I know will invariably come, is bound to further awaken or sustain our interest in the goings on in the electricity sector. I wish to especially thank each member of our panel for taking time out to offer us their insight. Overall, I cannot wait to get started on today's program. I heartily welcome everyone and wish us a richly rewarding couple of hours ahead. Well, that's where the formal speech ends, but let me quickly say that I am very impressed. I have started to look through this volume and I'm very impressed with the quality and the content. So let me also just very quickly give kudos to all those who put this together. I'm really glad to be here and I look forward to the engaging conversation that I know that we will be having. The MBA is really keen on ensuring that subject matter expertise is enhanced and that our lawyers can become sector experts and niche area experts so that we can better service this economy. So I am sure that this law report will help us achieve this objective generally. Thank you very much for your attention, and I wish us all very useful and fruitful deliberations. Thank you very much.
Thank you very much, Mr. Olumide Apata. Can we give another round of applause, please? Thank you. We do have a number of special guests in our midst, and do forgive me for not doing this earlier on, but I'd like to acknowledge the presence of His Excellency, Professor Yemi Oshibajo, SAN, GCON. He's not here, our Vice President, but he is ably represented by Mr. Alex Oko, Director General of the Bureau of Public Enterprises. Please give him a round of applause as he joins us virtually. Also in our midst is Honorable Commissioner for Energy and Mineral Resources, Lagos State, Engineer Olalere Odushote. Thank you for being here, sir. Oh, the claps are weak. Can we do a little bit better, please? Thank you. I know we're struggling, the masks and everything, but thank you so much. And also, Mr. Kemi Pinero, SAN FCIARB, Principal Partner Pinero LP. He's represented by Mr. Chukudi Enebele, Partner at Pinero LP. Thank you for being here and representing him. Thank you so much. Okay, without further ado, I'm going to call on Mr. Chukudi Enebele, Partner at Pinero LP, to do a review of the electricity law reports. Please welcome him as he comes.
Good afternoon, ladies and gentlemen. May I stand on existing protocol? But first of all, let me extend the apologies of Mr. Pinero SAN, who is unavailable absent today. He has also told me particularly to extend his apologies to the chairman of the editorial board, his leader, his friend, and his brother, Chief Ayorinde SAN, and also the editor-in-chief, Mr. Wale Irokosu, who is also his junior brother. I will go straight to the review of the book, of the law report. Your Excellencies, my lords, spiritual and judicial, distinguished ladies and gentlemen, very distinguished, educated, yet unlearned ladies and gentlemen, all protocol observed. Permit me to start this review on a note of commendation to the publishers of this specialized law report, the editor-in-chief, Mr. Wale Irokosu, team of editors, and the editorial advisory board led by my friend and brother, Silk, Chief Ayorinde SAN, OFR. They took on a pioneering task of producing the first ever law report containing decisions relating to the power sector and performed their task gracefully and commendably. There is absolutely no doubt that their diligence in compiling and editing the cases reported to ensure accuracy, deciding what is worth reporting, and providing useful and enlightening analysis of each reported decision makes this law report a delight to all researchers, investors in the power sectors, regulators, and legal practitioners. I commend them. A famous jurist, Justice Oliver Wendell Holmes of the U.S. Supreme Court, is noted to have described the law as being the prophecies of what the court would do, in fact, are nothing more pretentious. I cannot express how deeply humbled I was when the editor-in-chief invited me to review this first volume. On a lighter note, I remember a very humorous remark on the humongous electricity bill often generated by power distribution companies as follows. When I was young, I was scared of the dark. Now, when I get my electricity bill, I am afraid of the light. Well, I am convinced if that person truly knows his rights and how he can legally challenge a wrongly computed electricity bill, he probably would not be scared of the light. The electricity law report will provide him with the requisite legal materials to insist on his rights. The review. The electricity law report, as stated by the editor-in-chief, in its preface was bettered by the need to provide a reference material containing the interpretations of extant laws and regulations in the power sector for lawyers, consultants, and other professionals engaged in the industry, players as well as all regulators in the power sector. The industry of the editorial team was demonstrated in the first volume, which contains a detailed index of subject matters considered and decisions from the Court of Appeal, Ondo State High Court, National Electricity Regulatory Commission, NERC, Chancery Court in England, and the House of Lords. There are 11 cases reported in this volume, and those cases border on notable issues such as computation formula for estimated billing, whether an order of mandamus can be sought against power distribution companies, capacity to institute an action against distribution companies, claim in respect of electrocution arising from negligence, captive generation permit, breach of terms of license, fair hearing adjudication by NERC, risk arrangement, right of squatters, trespassers to power supply, and wait leave for installation of electric line. The structure in which the cases reported has been presented allows for easy understanding of the principles applied in those cases. In this regard, aside the succinct summary of fact, the editors seem to have taken into consideration the admonition of the Apex Court in the case of Dairo versus Union Bank of Nigeria that it is not desirable or ideal for a counsel to rely on site holdings or editor's summary of a case. That, in my view, is a lazy counsel's approach. A counsel who is serious must devote his time and attention to go deep into the judgment of a court in order to arrive at the exact holding of that court. This will certainly obviate an occurrence of avoidable mistakes. Hence, the head notes provided in the Electricity Law Report has been presented in such a way that editors' notes are not included. Only the ratio or highlight of the decision of the judges itself has been referenced in the head notes. This is very commendable. I therefore share the sentiments of the editor-in-chief when he also stated in his preface that this publication, with profound reference to all other existing law reports, is unparalleled in terms of its quality and is intended to provide a plethora of relevant authorities in the electric power sector unavailable in any other report. I must, however, state here that I find it interesting that of the 11 cases reported, 6 were initiated by individuals, and 3 out of those 6 cases by individuals were initiated by lawyers. Does this mean that lawyers are the major complainants in terms of power consumption? I certainly do not think so. I believe those cases are of public interest and were taken up by those lawyers for the benefit of the public, as the interpretation of the law in those cases is beneficial to all. I will invite attention to some of those cases because of the relevance of the subject matter considered. With the lethargy most times demonstrated by power distribution companies in failing to swiftly reconnect a consumer whose power supply has been disconnected after due payment has been made, the case of Just Electricity Distribution Company against Barrister Lethand John, citation reported, is very instructive. In that case, the respondent had sued the appellant distribution company seeking an order of mandamus to compel the appellant to reconnect power supply to his premises. The appellant filed an objection to the suit on the basis that there is no public duty to warrant an order of mandamus against it, as its relationship with the respondent is contractual. The Court of Appeal, in rejecting the contention of the appellant, relied on the provision of paragraph 9A to D of the Connection and Disconnection Regulation Procedure and stated that the respondent's relationship with the appellant is such that must be accorded mutual respect, being one that originated and is regulated by statute. From whichever way it is viewed, I will still come to the conclusion that the appellant-respondent's relationship is not contractual, but one which the law enjoins a duty to be performed. The case of Just Electricity Distribution Company versus Lethand John is a case which distribution companies should study with the finery of a tooth comb and live up to their responsibilities to prevent needless litigations. In the case initiated by my brother Silk before the National Electricity Regulatory Commission, Lagos, that is Funke Adekoya SAN against VGC Management and Maintenance Company Limited, the issue of bulk metering of residents of Victoria Garden City Estate managed by the respondent at the instance of a co-electricity distribution company, and the inconsistency between the Commission's approved tariff and those charged by the respondent was considered amongst other issues. In determining the dispute regarding the bulk metering arrangement, NERC resolved as follows. The electricity trading arrangement in VGT Estate is contrary to the provision of the EFSA Act, and it contravenes the terms of EEDC's electricity distribution license. VMMCL cannot unilaterally or in conjunction with EEDC increase electricity tariff payable by residents of VGC Estate. The resolution of NERC in the above cited case is very relevant, and all estate management companies ought to be guided by all the principles enunciated in the case. I will, in this regard, commend this decision, which, of course, can only be found in the Electricity Law Report, to all community development associations for proper guidance in respect of power distribution arrangements. I also find the case of Barrister Mike Pemi against Benin Electricity Distribution Company, decided by the Ondo State High Court, instructive. The decision in that case borders essentially on the vexed issue of metering and estimated billing by distribution companies. The case was instituted to challenge the arbitrary and unmetered billing of the appellant's residents. It was held that estimated billing is not at large, but subject to specific formula based on verifiable data, as provided in paragraph 7 and 8 of the Nigerian Electric Regulatory Commission Methodology for Estimated Billing Regulations 2012. It was a duty of the defendant, who solely keeps record of all details constituting input into formula for computation, to provide that the bills issued by the claimant conform to the prescription and formula for computation. The court further held that in the circumstances of the case, unless the appellant's house is metered, the appellant cannot be disconnected and can consume electricity without payment. Another case which I find interesting is the case of Lagos State Government of Nigeria against Power Holding Company of Nigeria. I find this case interesting because of the specific findings of NERC regarding a power contract containing an arbitration clause. In that case, the Lagos State Government had approached NERC via a petition complaining of a breach of the Barge Power Purchase Agreement, BPPA. The BPPA contains an arbitration clause. Hence, the respondent filed an objection to the petition that proceedings in relation to same be stayed pending reference to arbitration. NERC, in resolving the issue concerning the arbitration clause, held thus: statutory bodies performing regulatory functions would normally not succumb to the private contract of parties subject to regulation by which they, private parties, seek to resolve their disputes of sensitive public impact by arbitration. Notwithstanding the arbitration clause in the BPPA and contribution agreement, it is not all disputes between industry participants under the provisions of E.L.R. that are arbitrable. Whilst not disagreeing with NERC, I believe this issue should be tested in the regular courts as opposed to an executive tribunal, so that we can at least have a binding precedent on same. No doubt, the first volume of the Electricity Law Report is not only resourceful and insightful, but intellectually stimulating. All lawyers should have a copy in their library. Regulators and indeed professionals engaged in the power sector will also find the E.L.R. helpful. However, I must quickly express my concern that aside cases initiated before NERC, no decision of the Lagos State High Court, where many power-related disputes are being resolved on a daily basis, as has been cited. The editorial team should, in subsequent volumes, conduct more research into power-related cases decided in the Lagos State High Court and report same. Since Mr. Pinero has taken advantage of this book review to make a case for Lagos State, may I also make a case for Delta State, that cases from Delta State High Court should also be reported. I also urge the editorial team to undertake similar publications of all legislations and regulations governing the electricity bill sector for ease of reference by all practitioners. I find the Electricity Law Report to be an indispensable research material on the position of the law governing the power sector. I encourage my audience to get a copy of the law report and study the cases reported. In this regard, permit me to adopt the words of the Honorable Attorney General of the Federation and Minister of Justice, Mr. Abubakar Malami, Senior Advocate of Nigeria, in his captivating foreword, where he stated thus: the Electricity Law Report is a welcome addition to the existing statutes, regulations, and text in the electric power sector. Undoubtedly, it would also be a useful tool for judges, lawyers, and other stakeholders in the power sector. I also urge the editor-in-chief and the team of editors not to be contented with the progress made so far with respect to Volume 1 of the Electricity Law Report, but strive for a higher standard of an all-encompassing law report for the power sector as opined by David Rockefeller. If necessity is the mother of invention, this content is the father of progress. It has been my pleasure and privilege to review the resourceful first volume of the Electricity Law Report and the very relevant cases reported in same. I thank you all for your kind attention. Good afternoon.
Thank you very much, Mr. Kemi Pinero, SAN FCIARB, as represented by Mr. Chukwudi Enebele, partner at Pinero LP. Thank you. Can we give him another round of applause, please? Thank you. We're just going to switch the program around just a little bit as we'll be taking on the representative of His Excellency Professor Yemi Osinbajo, Mr. Alex Oko. He'll be coming up virtually to give a keynote presentation. Mr. Alex Oko is the Director General, Bureau of Public Enterprises, so please welcome him as he joins us online. And while we're getting him online, I would like to acknowledge the presence of Mr. Akingbolaho Adeniro, Attorney General and Commissioner of Ogun State. He is joining us virtually as well. Can we give him a round of applause for joining us?
Yeah, good afternoon, ladies and gentlemen. His Excellency, the Vice President, Professor Yemi Osinbajo, has asked me to convey his very warm felicitations to the organizers and the participants at this event, and also his best wishes for an impactful and successful outcome of your deliberations. Incidentally, His Excellency is unable to be here this afternoon, so he's asked me to deliver the keynote address on his behalf, and it is my honor and privilege to proceed to do just that. The chairman of this event, Mr. Aderenima Kojuola, represented by Professor Gbolahan Elias, SAN, the president of the Nigerian Bar Association, Mr. Olumide Apata, SAN, the Lagos State Commissioner for Energy and Mineral Resources, the reviewer, Electricity Law Reports, Mr. Kemi Pinero, SAN, the editorial board, the moderator and panelists, guests and participants, including those joining online, distinguished ladies and gentlemen. I would like to begin by expressing my thanks and appreciation to the organizers of this event, Probitas Partners and SQS Publishing Limited, for the very kind invitation to deliver the keynote paper at this August occasion. I also wish to congratulate you as you launch the maiden edition of the Electricity Law Report. The topic of this discourse, ladies and gentlemen, the Nigerian power sector privatization, the way forward, is one that is most pertinent, especially at this time, given the critical importance of power to the economic and social life of the nation, but perhaps more so considering the various robust interventions currently being executed by the government to ensure a more stable and viable power sector in Nigeria. As we all know, electricity supply is one of the most important catalysts for economic growth and development, as well as an important social utility which ensures decent and comfortable standard of living of the citizens of a nation. It is also a known fact that for many decades, Nigeria has struggled to provide stable electricity for its citizens. Please recall, ladies and gentlemen, that in 1999, the power sector was in a particularly deplorable state. The following statistics make the point, I believe, quite clearly. Only 19 out of the 79 generation units in Nigeria were operational as at that time. Average daily electricity generation was around 1,750 megawatts. The newest generation plant, as at 1999, was completed in 1990. The last transmission line was constructed in 1987. Over 60% of the population was without access to the national grid. The aggregate technical, commercial, and collection losses were estimated to exceed 50%, and overall funding of the sector was extremely poor. In order to address the issues in the power sector, some of which I have alluded to in the foregoing, an ambitious reform and privatization program was initiated by government, which involved, amongst others, the enactment of the Electric Power Sector Reform Act in 2005, the establishment of a new sector regulator, the Nigerian Electricity Regulatory Commission, and the unbundling of the then power holding company into three segments: generation, distribution, and transmission, which of course culminated in the sale and handover of the distribution and generation successor companies to private sector investors, whilst the transmission company of Nigeria remained under government control. However, post-privatization, the sector has experienced certain challenges stemming from the technical and commercial misalignment, which has led to high technical and commercial losses by operators and resulted in a suboptimal market performance. Notwithstanding the foregoing, let me assure you that this administration is firmly committed to resolving these challenges and turning around the sector in order to achieve Mr. President's objective to deliver efficient, stable, reliable, and affordable power to the generality of Nigerians. This, in turn, will help to place the country on the path of economic recovery, given the hugely disruptive effects of the COVID-19 pandemic, and ultimately unlock economic growth. In view of this, the federal government has initiated a series of intervention programs designed to deliberately address the challenges in the power sector from two broad categories. One, commercial viability, and the second category is technical and infrastructure capacity. I will discuss these programs briefly. Commercially, distinguished ladies and gentlemen, it is important to note that a commercially viable power sector is critical and essential to the success of the privatization program. If commercial viability can't be achieved, there will be no need to privatize in the first place. However, commercial viability has to be balanced with social responsibility. And this is the main thrust of one of the key initiatives of the government in this regard, the Power Sector Recovery Program. In order to address the commercial challenges in the sector, the Federal Executive Council in March 2017 approved the Power Sector Recovery Program. Pursuant to this, the relevant agencies of the federal government have worked assiduously with the World Bank to map out a strategy for the execution of this laudable program. The Power Sector Recovery Program is a performance-based initiative designed to, one, establish a conducive policy and regulatory environment for the power sector, particularly to strengthen the performance of the electricity distribution companies. Two, to achieve financial and fiscal stability in the sector. And three, to enhance accountability in the sector, with the overall objective of ensuring the provision of quality and reliable electricity supply. This will enable the federal government to redirect vital resources currently being deployed as a lifeline in support of the sector towards other critical areas such as health, education, and infrastructure development. It will also make the sector attractive for necessary private sector investment. A significant milestone was achieved in June 2020 when the World Bank approved a credit facility on concessionary terms in the sum of $750 million for the purpose of financing the implementation of the power sector recovery program. Permit me to then discuss some of the issues around the technical category. The following initiatives have been instituted by the federal government to tackle the technical constraints in the sector. One, the Presidential Power Initiative. The first, ladies and gentlemen, is the Presidential Power Initiative. This is a joint commitment between the federal government and the German government to address the infrastructure gaps in the transmission and distribution networks with a view to expanding capacity for future power needs. In view of this, Siemens AG has been engaged to undertake an end-to-end grid modernization and expansion project. The Presidential Power Initiative is structured into 3 phases aimed at improving operational efficiencies and increasing power delivered to Nigerians. The phase 1 will focus on implementing projects that will, within a short period of time, greatly improve power supply in Nigeria. The objectives of the phase 1 of this project are 1, to deliver an additional 2 gigawatts, that's 2,000 megawatts to the grid, thereby increasing the grid capacity to 7,000 megawatts. 2, to significantly reduce aggregate technical, commercial, and collection losses. And 3, to achieve improved grid stability and reliability. The phase 2 will target bringing the grid's operational capacity to 11 gigawatts, while the third phase will involve increasing the grid's operational capacity to 25 gigawatts within a medium to long-term planning period, with appropriate upgrades and expansions in transmission and distribution. This network improvement initiative is one of the most important levers of the power sector in the post-privatization era. The second program on the technical infrastructure dimension is the World Bank Distribution Rehabilitation Program. This initiative targets the distribution segment of the Nigerian electricity supply industry by providing concessionary financing to the electricity distribution companies for the purpose of executing key priority projects identified in their various performance improvement plans. A key area of focus of this intervention, of course, is mass metering of customers. The third initiative on the technical category is the African Development Bank Distribution Rehabilitation Program. The federal government is also in discussions with the African Development Bank to provide concessionary financing to the electricity distribution companies in order to resolve the critical interface issues between TCN and the electricity distribution companies. This, we believe, will drastically expand the ability of TCN to transmit power to locations required and reduce the incidence of rejection of power by the electricity distribution companies. It will also increase the ability of these companies, the DISCOs, to distribute more quality and reliable power to end users. The African Development Bank has signaled an intention to advance a sum of $350 million facility to fund the first phase of the program, with the possibility of doubling this amount for the second phase. The fourth perspective on the technical category is the mass metering. Please recall also that in August this year, His Excellency President Muhammadu Buhari issued directives for mass metering of unmetered electricity customers in order to put an end to estimated billing, and approved the waiver of import duties on meters for a period of 12 months. Distinguished ladies and gentlemen, in addition, I'm pleased to mention that the federal government is in the process of concluding 2 power sector privatization transactions. The privatization of Afam Power PLC and Afam 3 Fast Power, and of course the reprivatization of the E.L.R electricity distribution company. Afam Power, with an installed capacity of 970 megawatts, will immediately add 240 megawatts to the grid, and this will be ramped up over time, while the reprivatization of E.L.R will attract operational efficiencies into the company and boost power distribution. In conclusion, it is clear that without resolving the issues in the power sector, Nigeria's economic growth is likely to be suboptimal. Distinguished ladies and gentlemen, let me assure you once again that this administration, under the leadership of Mr. President, understands the various challenges that have plagued the sector and is committed to, and indeed has taken positive strides towards resolving them in order to fulfill its promise to provide stable, quality, and reliable power to Nigerians. As an administration that encourages continuous engagement and robust views and feedback on solution possibilities, I look forward to your deliberations today in the hope that we'll be able to glean constructive thoughts, ideas, and viable suggestions on how to better deliver an efficient, viable, and socially responsible power sector in Nigeria. I thank you for your kind attention, and God bless you, and God bless Nigeria. Thank you very much.
Thank you very much, His Excellency Professor Yemi Osinbajo, SAN, GCO, and Vice President of the Federal Republic of Nigeria, as represented by Mr. Alex Oko, Director General, Bureau of Public Enterprises. Thank you very much. Can we give them another round of applause? I would like to acknowledge the presence of another special guest who is joining us online, Alhaji Femi Okunu, SAN, CON, founding partner of Femi Okunu Chambers. Can we give him a round of applause, please? Thank you for joining us, sir. At this time, I'm going to call on our next keynote speaker to share his presentation. Honorable Commissioner of Energy and Mineral Resources, Lagos State, Engineer Olalere Odushote. Please welcome him as he comes.
His Excellency, the Vice President of the Federal Republic of Nigeria, Professor Yemi Osinbajo, SAN, GCON. Special guest of honor, Mr. Olumide Akpata, the President of the Nigerian Bar Association. The reviewer, Mr. Kemi Pinero, represented by Mr. Chukwudi Enebeli. The Chairman of the panel, Mr. Aderemi Makonjuola, represented by Professor Gbolahan Elias. Distinguished panelists, especially my chairman, the honorable member of the 8th Lagos State House of Assembly representing Ikeja Constituency 1, and also the chairman of the Lagos State House of Assembly Committee on Energy and Mineral Resources, Mr. Folajimi Mohammed. Distinguished panelists, members of the Fourth Estate, distinguished ladies and gentlemen, both present and logged in from locations around the world. It is my pleasure, indeed I consider it an honor, to deliver this keynote address at the launch of Electricity Law Reports on the topic, Nigeria Power Sector Privatization, the Way Forward. From the focal point of Lagos State Government's efforts to navigate the challenges in the electricity sector post-privatization. Let's start by talking about what energy is. It's defined as the vitality required for sustained activity, the lack of which would leave you in a comatose and vegetative state. Electricity, a form of energy, has been acknowledged as the driver of the second industrial revolution. The role of a reliable and adequate electricity supply industry in our future development cannot be overemphasized. From a social and economic standpoint, The availability of a dependable public electricity supply will lead to a better standard of living for Lagosians, better opportunities for social mobility, and access by all citizens to social and physical infrastructure. It lowers the cost of doing business and the cost of living. It frees up funds for investment by both public and private sector and leads to savings by the citizenry. It enables the creation of more jobs and a massive reduction in the numbers of those living below the poverty line. Very importantly, it increases the tax revenues and thus public funds available for investment in social infrastructure and to enable growth. Electricity law reports is timely and important at this point in our development, as electricity laws and key judicial decisions play a crucial role in defining and assuring an enabling environment for investors and industry stakeholders beyond legal practitioners. The analysis and commentaries on relevant judicial decisions contained in the report serve as an important reference for industry regulators, professionals, companies in the industry, and even end users. In Nigeria, the electricity reform process began in earnest in 2005 with the enactment of the Electric Power Sector Reform Act and the subsequent unbundling of the electricity supply industry in Nigeria. This was followed in 2013 by the privatization of the successor companies, with the exception of the Transmission Company of Nigeria. The promise of reliable electricity that the privatization promised has continued to elude Nigerian populace in general and Lagosians in particular. Today, it is estimated that 8 million Lagosians are either without access to electricity or underserved, getting an average of 12 hours of electricity supply or less. The average daily supply to Lagos from the national grid is less than 900 megawatts. When you consider that an assessment conducted in 2014 by the Lagos State Electricity Board indicated that the Lagos population deploys up to 15,000 megawatts of self-generation, it is clear that with under 900 megawatt supply from the national grid, the energy needs of Lagos are not being met. And given the fact that Lagos is arguably the fastest growing metropolis in the world, that gap in energy supply is growing exponentially. Lagos State cannot depend for its electricity supply on a planning system that has other jurisdictions to contend with. The obvious conclusion, therefore, is that Lagos State must chart its own course in seeking energy for its residential, commercial, special, and industrial constituents. Lagos State made a first attempt at electricity intervention by supporting the establishment of a 270 megawatt power barge project that was supposed to dedicate some of its capacity to identified critical sectors in Lagos. This effort failed spectacularly due to its dependence on federal government industry support. That support was found wanting. In later years, Lagos State has promoted the development of small independent power plants across the state. These IPPs were set up to serve LESG assets and infrastructure as their anchor customers, but could not evolve beyond their total capacity of under 50 megawatts due largely to the absence of a clear regulatory framework for these IPPs to supply power to industrial, commercial, and other residential customers. In addition to these, solar assets have been deployed to 213 schools and primary healthcare centers in the state. In 2018, the Lagos State government passed the Lagos State Electricity Power Sector Reform Act, which was aimed at boosting electricity supply in Lagos State through the establishment of an embedded power scheme and the creation of offenses for energy theft. In spite of the presence of all the elements, constitutional, legal, engineering, commercial, and financial, necessary to establish a viable, vibrant, and innovative electricity market, the law did not quite do enough to advance the state towards this vital strategic goal, as the embedded power scheme was not actualized. Upon further assessment of the needs in the sector, it became clear to us that transmission and last mile electricity distribution, including metering, were the key bottlenecks in a sector that currently has 3,500 megawatts of stranded generation capacity from one company. We also received feedback from the border industry on the inadequacy of this existing law
to fully cater to broader electricity supply solutions available in the state, including renewable energy, energy efficiency, distribution franchising, and such other useful approaches to drive investment into the electricity sector in the state. The 2018 law was a very important indication by Lagos State of its intent to drive reliable access to electricity in the state and serve to instill confidence in key stakeholders in the Nigerian electricity supply industry, especially the players in the Lagos State. Today, the Babajide Olusola Sanwo-Olu administration remains focused on encouraging businesses and ventures to thrive and innovate through policies and programs that reduce the burden of carrying out business in the state, and will continue to work hard to improve the supporting policies, regulations, and infrastructure. We are committed to partnering with relevant stakeholders in the industry to light up Lagos sustainably. To do this, we have identified and commenced work on key policies and regulations, as well as other strategies to ensure reliable electricity access in the state. First, we understand that an integrated resource plan is key in enabling the state to meet future electricity demand. An IRP considers a wide range of supply and demand resources and their financial, economic, and environmental impact with regards to meeting projected future power needs in the state. Lagos State has thus commenced work on an integrated energy resource plan for Lagos State, working with Power Africa Nigeria Power Sector Program, the U.S. Agency for International Development's Power Electrification Program in Nigeria. This study includes load demand forecasting, demand-side management programs, generation systems expansion planning, transmission system expansion planning as it relates to the state, distribution system expansion planning, and much more. This will deliver a short-term, medium-term, and long-term implementation plan for improvement in the state. Secondly, we recognize the need for an enabling environment supported by a clear and unambiguous statement of intention by the government to foster investment in the electricity sector. Lagos State is in the process of outlining its electricity policy, which will serve to provide direction from the Lagos State government on improving the livelihoods of Lagosians through improving electricity supply in the state. This policy will capture renewable energy, noise and pollution guidelines for electrified zones, electricity theft control and penalties, registration of power suppliers and developers, electricity safety and standardization, and the licensing of electricity workers. Third, we recognize that policies need to be backed by laws, and so we are reviewing the 2018 Lagos State Electricity Power Sector Law. On June 24, 2020, the Ministry of Energy and Mineral Resources issued a call for papers and comments on the Lagos State Electricity Power Sector Reform Law 2018, as well as suggestions on regulations necessary to drive investment into the energy sector of the state. All submissions were received on July 3rd and are being reviewed and incorporated into the updates. In addition, to ultimately achieve the much desired synergy between the various agencies of government saddled with the responsibility of regulating the power sector and to remove bureaucratic constraints to doing business in Lagos, we're reviewing our regulatory mandate with a view to eliminating the delays in procuring necessary approvals, and our private partners will now have to deal with just one or two government entities. While continuing to make laws and enforce policies, the state government has embarked on another initiative in its Light Up Lagos program to ensure the full metering of Lagos, one community at a time, in partnership with the DISCOs and other providers. This, we believe, will unlock the bottlenecks in the last mile infrastructure and drive reliable energy delivery to our citizens. Today, over 60% of electricity customers in Lagos are unmetered. We believe that improving metering in these communities would increase willingness to pay, improve productivity, and more importantly, continue to improve the living conditions of our people. It will also lead to loss reduction to the DISCOs in Lagos. Working with our partners, we have identified underserved areas that can be used as pilot zones for supply excellence. We have conducted site assessments in 6 low-income, high-population communities with support from the German International Development Agency, GIZ. The state will support the necessary community engagements to ensure sustainability of this model, backed by the necessary regulations to minimize theft, along with an enforcement mechanism. Continuing with the promise of the BOS campaign, Lagos State is listening and encouraging the citizenry. Last month, we launched the Lagos Smart Meter Hackathon 2020 to leverage local capacity towards improving electricity distribution and monitoring. We expect to encourage the local design and production of affordable meters to drive reliable electricity supply for all. This will encourage the young to focus their energies and creativity on providing audacious solutions to our unusual Nigerian situation. In the short time frame given, there were 65 impressive meter prototype and metering software submissions, demonstrating the depth of young talent that exists in Lagos State. We continue to believe that sustainable public lighting remains a key part of the security architecture of Lagos. We have embarked upon the conversion of all street lights in Lagos from HPS to the brighter and significantly more efficient light emitting diodes. All 39,000 street lights in Lagos will be retrofitted over the next 6 months and will lead to a 65% reduction in operational costs to the state government. We will further expand the street lighting to ensure that before the end of this administration, all Class A and B roads, as well as designated public spaces, will achieve full lighting coverage. Let me reiterate that for Lagos State to achieve electricity sufficiency and reliability, it needs to have an electricity sector that is focused solely and entirely on serving the geographical space that is Lagos. We intend to collaborate with the federal government and its agencies to achieve the application of their particular strengths in support of market growth and customer satisfaction. Distinguished ladies and gentlemen, the market is in Lagos. The potentials of return on investment is huge. Lagos State occupies 0.4% of the Nigerian landmass and is yet host to 12% of Nigerians. This population is increasing on a daily basis by at least 2,000 people. That's almost 1 million a year, just from migration alone. As a government, we are ready to drive the institutional framework that will provide a conducive, investor-friendly environment that will encourage and support private sector investment. In closing, ladies and gentlemen, let me assure you that Lagos State will continue to actively engage with stakeholders as we strive to make Lagos State a 21st century economy, building on an enabling electricity policy framework backed by supporting laws. Thank you.
Thank you very much, Engineer Olalere Odushote, Commissioner for Energy and Mineral Resources, Lagos State. Thank you so much for all of that information. Okay, we're going to switch gears just a little bit and move to our panel discussion. And I will be introducing our panelists as they come up on the podium. Just permit me to read a few profiles here. I'm going to call on Mr. Dafe Akbeneye, Commissioner of Legal, Licensing and Compliance Division of NERC. I'm going to ask him to please come on stage as I read his profile. Mr. Dafe C. Akbeneye is the Commissioner that leads the Legal, Licensing and Compliance Division at NERC. In this role, he is primarily responsible for issuing licenses to all participants in the Nigerian electricity supply industry, enforcing the provisions of the Electric Power Sector Reform Act, and resolving industry complaints and disputes. He graduated from the Obafemi Awolowo University with a bachelor's degree of law in 2001 and was admitted to the Nigerian bar in 2003. He worked briefly with the law firm Jude Idigbe & Co. before proceeding to join Ibrahim Yakubu & Co. in Lokoja for his youth service. He joined the leading commercial firm Ajumogobia & Okeke upon his return to Lagos in 2004, where he worked until he joined the Nigerian member firm of the PricewaterhouseCoopers Global Network in December 2005. He led the regulatory services practice at PwC Nigeria and was also the general counsel of the firm in Anglophone West Africa until his resignation on January 31st, 2017, to take on the role at NERC following his nomination as a commissioner by the President in July 2016 and subsequent confirmation by the Senate in January 2017. He is a member of the Nigerian Bar Association, Chartered Institute of Taxation of Nigeria, and the Chartered Institute of Arbitrators UK. Please join me to welcome Honorable Commissioner Dafe Akpaneye. Thank you, sir. I'm going to call on Mrs. Falake Shoeton. She was appointed as the acting CEO of E.L.R Electric PLC effective March 1st, 2020. She's a graduate of banking and finance from the University of Lagos with over 20 years of experience in management of startups, sales, and marketing, change management as well, and over 13 years in a myriad of leadership roles. Her experience spans the aviation, oil and gas, and power sectors in Nigeria and Ghana, where she honed her skills in Halliburton, British Airways, Virgin Nigeria, and Sahara Group. She joined Sahara Group in 2009 and worked in one of its key entities, SO Aviation in Ghana, as the Vice President Downstream West Africa, and was primarily responsible for 3 Ghanaian subsidiary companies managing a turnaround project, signing up international businesses, and moving the company from number 7 to number 3. She has experience in change management and business turnaround, and that saw her join the management of Nigeria's largest electricity distribution company, E.L.R Electric, as Chief Commercial Officer. Now, at E.L.R Electric, Falake led a team of over 800 people tasked with developing and implementing strategies that has helped the company reduce its aggregate technical, commercial, and collection losses from over 40% to about 26% in 4 years. Now, that's the first in the history of the Nigerian power industry. She was elevated to being the first female chief operating officer at E.L.R Electric PLC, where she was responsible for developing and implementing strategies to increase customer growth through service delivery, reduce energy losses associated with power distribution, optimization of the technical infrastructure, increase revenues, and strengthen the overall performance of the business. She has, over the years, garnered several certifications in various professional fields. Ladies and gentlemen, please welcome Mrs. Falake Shoeton. Okay. I'm also going to call on Honorable Falajimi Lai Mohammed, Chairman, Lagos State Committee on Energy. Please welcome him as he comes. Honorable Falajimi Mohammed is a member of the newly inaugurated 8th Lagos State House of Assembly representing Ikeja constituency. And prior to his assumption of office as legislator, he was trained as a lawyer and worked at notable commercial and corporate law firms in Lagos, including Chief F.R.A. Williams, Ajumogobia, and Okeke, as well as the Jackson, Eti, and Edu, where he delivered exemplary expertise in corporate management and counseling. Now, following his passion for legal practice, he proceeded to set up a law firm, ATAS, where he is a partner. Having garnered enough experience in the legal practice, particularly in management, he then made a transition into a more traditional business role, becoming the managing director of Knightsbridge Dredging Limited. He deployed his distinct entrepreneurial prowess, leadership, and accountability, thereby taking the business to an admirable level in its industry before he eventually joined the public sector. He's a sports enthusiast with particular interest in football, and his education background includes LLB honors at the University of Kent at Canterbury, UK in 2001. Ladies and gentlemen, please join me to welcome Honorable Falajimi Lai Mohammed. Also joining us is Mr. Yunana Jack Malo. Can he please come up on stage? Welcome, sir. Thank you for joining us. He is the Director of Energy of the Energy Department, Bureau of Public Enterprises. Also joining us, but virtually, Mr. Akin Akinfemiwa, Managing Director, Gerugu Power Limited, PLC. Mr. Akin Akinfemiwa is the Chief Executive Officer of Gerugu Power PLC, one of the best performing power generations companies in Nigeria. Prior to his current role, he served as the Chief Executive Officer of Forte Oil for 8 years, from 2011 to 2019. Under Akinfemiwa leadership, Forte Oil PLC went from 6th position to second largest major oil marketing company, in Nigeria. He advocated for better operating conditions for oil marketing companies as a member of the Major Oil Marketers Association of Nigeria, MOMAN, and his dogged advocacy culminated in his appointment as the chairman of the association for a 2-year tenure during the most notable turbulent times in the industry. Now, over this period, he earned recognition for his excellent leadership and was awarded Top CEO by Business Day Media for 3 consecutive years. Akin Akifemiwa's professional journey is filled with transformative and result-oriented milestones of leading various companies to sustained growth and profitability. His most notable turnaround achievements at Forte Oil include reversing a huge 19 billion naira loss, restructuring of the operations, and returning the business to profitability through strengthening of service delivery, attracting talent, diversifying the portfolio to include power generation, oil field services, and operations in Ghana. Ladies and gentlemen, he's joining us virtually, Mr. Akin Akinfemiwa. Please give him a round of applause. I'm going to read Mr. Unana Jack Del Malo's profile. He is the Director, Energy Department of Bureau of Public Enterprises, as I mentioned earlier. And before joining the Bureau in 1993, he worked as lecturer in the Department of Economics at University of Jos between 1989 and 1992. Mr. Unana's main responsibilities in that capacity included lecturing, research work, assisting senior lecturers with tutorials, and other duties assigned by the department. He joined the Bureau, then Technical Committee on Privatization and Commercialization in 1993, and he anchored the committee work that produced the Nigerian National Petroleum Policy. He was involved in the reform of the telecommunications sector and several attempts to privatize NITEL, as well as its eventual liquidation. He also served as special assistant to 3 former director generals of the Bureau. And over the years, Mr. Unana has served the Bureau in various capacities and actively participated in several sector reform processes as he rose to his current rank as Director, Energy Department. Once again, please join me to welcome Mr. Unana Jack Del Malo. And last but certainly not least, I'm going to call on our moderator for today, Ms. Rahila Thomas. She is the director of MRC Group, and she has over 16 years of experience in the power sector. She's a power sector strategist with a deep understanding of the electricity industry dynamics, and she has expertise in policy development, power sector reform, regulation, and power market design, and power project developments. Now, in Nigeria, Ms. Thomas has supported both GENCOs and DISCOs through the privatization process that resulted in the handover in November 2013. And following the handover, she has continued to support private sector investors in the newly privatized power sector in Nigeria, including distribution, hydro, and thermal generation. And her numerous assignments include assessment of the market for solar power and decentralized renewables in the Nigerian private sector as well. Now, her other work for developers include due diligence for prospecting investors, preparation of information memorandum for quantum power, and the developers of the Yellowstone IPP. Now, she's advising the Association of Nigerian Electric Distributors, the DISCO Roundtable, on regulatory, commercial, and power markets matters, as well as the DISCO's Investors Group. She previously worked as technical advisor on the regulatory and transaction team of the Nigerian Presidential Task Force on Power and held several advisory positions to ministers of the power sector from 2008 to 2012. Now, prior to that, she was a core member of the electric power team of Nigeria, or rather of the Nigerian Bureau of Public Enterprises, in driving the Nigeria power sector reform program. She was involved in the unbundling process of PHCN and the development of the new market and earlier privatization processes. Ms. Thomas was also appointed Technical Assistant on Energy to the Minister and Deputy Chairman of the National Planning Commission in Abuja. And she has unrivaled knowledge of all aspects of the Nigerian power sector. She holds a bachelor's degree in business administration and a master's degree in energy studies with specialization in energy finance from the Center for Energy, Petroleum and Mineral Law and Policy in the UK. Please join me in welcome Ms. Thomas on the stage. And just to mention, as I mentioned, we had a slight change in the program. Mr. Unana Jackdale Malo is representing Mr. Alex Oko. So I'm just going to read out Mr. Alex Oko's profile, just so that he was supposed to be on the panel, but he's being represented by Mr. Malo. So I think it's important that we read his profile as well. Mr. Alexander Ayola Oko was appointed the Director General of the Bureau of Public Enterprises in April 2017. Prior to his appointment, he was the managing partner of Ashford and Maguire Consulting Limited, a leading wholly indigenous management consulting firm. He is currently a member of the Presidential Economic Advisory Council and has 32 years experience, 22 of which were in banking, where his responsibilities involved general management, leadership, and organizational development. He was the managing director and CEO of NNB International Bank PLC from 2001 to 2006, where his visionary leadership took the bank from a comatose state to a positive position of enhanced value for stakeholders. His banking career saw him working for Nigeria International Bank Limited, Citibank, and United Bank for Africa PLC, while his international experience included stints with Citibank New York, Fidelity Bank London, Swiss Banking Corporation Zurich, and Grindlays Bank Zimbabwe. Mr. Oko studied sociology at the University of Benin and holds a master's degree in banking and finance from the University of Ibadan. He is also an alumnus of the Harvard Business School's Advanced Management Program. We can just give him a round of applause, even though he's joining us online. And at this time, I'm going to hand over to Ms. Rahila Thomas. She will be moderating this discourse.
So, the Nigerian journey of reform started in 2001 with the National Electric Power Policy put in place, followed by the enactment of E.L.R in 2004, but it is known as E.L.R 2005 for some reason, but it was enacted in 2004, and this led, of course, to privatization in 2013. So the handover of 6 generation companies and 11 distribution companies to private sector ownership to attract private capital, to increase power supply, to reduce inherent inefficiencies in the electricity value chain. The private investors who bought these companies came on board with the best crop of technical partners. I would like to mention 3 in particular. Tata Power Delhi Distribution Limited, which has a dynamic experience in power distribution business, has been the most successful private discom of India. Tata Power has an installed electricity generation capacity of 10,577 megawatts. It is India's largest integrated power electricity company. NERC is the largest private sector electric distribution utility company in the Philippines, covering 36 cities and 75 municipalities, which is about 10% of our local government here in Nigeria, and of course in Lagos we have about 37, so comparatively a very good coverage. The third one I'd like to mention is CMEC. CMEC is China Machinery Engineering Corporation. One of its specializations is construction of power projects in generation, transmission, and distribution. It ranks 6th among global international contractors in terms of total revenue generated from international contracting work in the power sector performed in 2010. This is 3 years before we privatized. But it's almost 7 years post-privatization, and the Nigerian power sector is still at the same level of generation, averaging between 3,500 megawatts and 4,500 megawatts. For most of the investors, their equity has been completely eroded. A majority of over 10 million Registered customers today are extremely unhappy with electricity supply. Labor is up in arms, and the government having spent over $4 billion in intervention is in a precarious fiscal position in light of the global pandemic and, of course, the downturn of oil revenues. So, what is the way forward? How can we turn the situation around is really the focus of our panel discussion today. And with me, these distinguished panelists who I believe will give us great insights on this topic. To start it out, I would like to ask the mother of privatization, presented here tonight, this evening, by Mr. Mario. Mr. Mario, the objectives of the NERC reform, supported by E.L.R, which led to the privatization of generation distribution companies in 2013, was to, amongst others, increase access and bridge demand-supply gap, improve efficiency in the value chain, and attract private capital. How would you say this has been? Have these objectives been largely achieved? Obviously, from all the background conversation we've had and the keynote address, we see that we still have some problems, but I'd like to have some insights from you. Thank you.
Thank you very much. So, thank you very much, Regulator, for panelists. I also want to stand on existing protocols. I want to thank you for this opportunity to discuss the power sector, a very critical requirement for our development, just like we've heard from some of our keynote address, that power is such a critical requirement for the development of this country. Now, we discovered prior to the privatization program that if you are able to improve power by a certain percentage, GDP will grow almost significantly within a short period of time if you're able to get your power supply correctly. And that informed the need to move away from power becoming a utility to power becoming a commodity. And that particular move saw the need to decouple the power outfits in the country at that time. The Ministry of Power was both a regulator, a policymaker, as well as an operator. And it became very clear that there was a need for both NEPA and the Ministry of Power to have separate responsibilities so that everybody can focus on a particular area. The Ministry on policy, the various components that were then NEPA that later became PSCN were involved in operations, and there was a need for a regulator in order to have the kind of system that will enable the power sector function efficiently, in the sense that those that are able to enjoy power can enjoy power equitably without neglecting those that are considered to be poor. So with the regulator, the policymaker, then the operators can play within the system. With that system embedded in the Power Sector Act, the background became very clear that the reform can be taken to the next step, which was the privatization. Like Rahila rightly said, that was the objective, to attract private capital into the power sector, to also make sure that we have increased access. Just like my DG said, at that time, access to power was very poor. To also ensure that we have efficient power. One can say that these objectives are still very much in focus. We have not attained them. We are working towards them, and I believe we are going to achieve them. Like my DG will always say, that we did the reform and worked on the patient in a very serious operation, just like the medical doctors would. And then we succeeded in the operation. We left the patient on the operation table, and everybody just left the patient. And agreed without anybody to take care of. And I think it's the issue of nurturing that was significantly not available when it mattered most. And I'm sure in the course of this discussion, we will come to those issues that are being taken care of, just like we had in the keynote address, that are going to put the sector, or are putting the sector in a better pedestal to deliver these objectives, as you rightly highlighted.
Excellent. Okay, thank you very much, Mr. Malo. So I guess from what you're saying is work in progress. However, I would like to follow this on by insights from the Commissioner of the DAFE, Akpeneya. What I would like for us to hear is the regulatory point of view of this. Why is it that we haven't been able to achieve it from a regulatory point of view? I mean, 7 years, generation is still very low, losses are high, customers, are unhappy. What's your contribution to this conversation, going from what Mr. Malo has just shared?
Okay. I take a rather different view from Mr. Malo, in that we didn't leave the patient lying on the table after the operation. We carried out the most ambitious power prioritization on the continent of Africa. And we took the UK model that was developed by Margaret Thatcher, that entails creating a piece of enabling legislation, creating a regulator, and unbundling. If you look at how other jurisdictions went about this, they were a bit selective in the unbundling, and they were a bit more prescriptive in the powers given to the regulator. We went about it in being very aggressive with the unbundling and not so prescriptive with the powers of the regulator. So you spoke about India. India, government retained privatization, distribution, with the exception of a part of Delhi, not the whole of Delhi, just a small part of Delhi and Modi state. Those are the only two places in India where you have private sector distribution. So what they did was they only unbundled generation. In fact, India delicensed generation. Generation is no longer an activity that requires a license. And once you can meet up with the technical requirements in India for a plant, you can come onto the grid. And anyone who understands the sector knows how difficult that is. But we went all out and we were very aggressive. But so the way the sector works is you have your feedstock at one end. It's either hydro or gas. And most of Nigeria's feedstock is gas, so it's thermal. Now, those guys have a gas supply and transportation agreement with the GENCO. The GENCO has a power purchase agreement with MBET, who has undertaken the power contracting for everybody. Now, MBET has a relationship with TCN to bring that power on grid. And MBET also has a vesting contract with all the 11 discos in Nigeria. What sustains this is all of us sitting in this room. In that entire structure is dependent on the financial flow from those of us seated in this room as customers. And you now have multi-tiered agreements with complex obligations. And if you look at upstream, the GENCOs, a few of them have contractual obligations that even affects our sovereign standing as a country. So you've done it that you've looked at the dynamics. Oh, beautiful on paper, 210 million people, largest economy in Africa. But if the political economy doesn't allow the power sector to stand as a sector whereby the economic flows can go from customer all the way upstream, you're going to have a problem. And that's why we haven't, it's perceived that we haven't achieved what we ought to have achieved, and government has had to intervene. So when you look at it, there are issues with the political economy in that power is still a political issue. It's still an issue that if a politician is campaigning in my village in Abraka, he will tell you that, oh, I will give you light. So it's no longer seen as a purely commercial issue. No one campaigns about telecoms anymore. GSM is not a campaign issue, right? Because it's something we now take as a given. And you now add the issues you have on the political economy with the issues that my profession has given to it as well, the lawyers. Which was one of the reasons why I took interest when the editor invited me, and I said I would come. Nigeria is the only jurisdiction, because we like to pick only, right? It's the only jurisdiction whereby a regulator did a tariff review, and someone went to court to challenge that tariff review. And the court ruled in his favor. Only jurisdiction. So I dare anyone to go and to prove me wrong. I'd say, oh, that's not right. There's another jurisdiction. You see, the consequences that portends. It's like the central bank changes interest rates for banking. And someone goes to court and says, central bank, you do not have the power to change interest rates.
Yeah.
Right? That's not possible. You see, so when you look at those two legs, and the consequence of that singular decision, of that case where a lawyer goes to court to challenge the 2015 tariff review, means from 2015 until we obtained judgment in our favor in 2018, we couldn't do anything with the tariffs. That resulted in government intervening. And the government intervention on the basis of just one judgment has cost this country over 1.5 trillion naira. And we've dug a deep hole that we are trying to get out of. I think that once we address it, the political economy and my profession has a big role to play. And we need to treat this sector the way other jurisdictions treat this sector. In that, one, like they do in the US, the courts in the US stand by the rule that the administrative body created by government, by Congress, over a sphere of activity is the authority over that activity. Yeah. And in the exception of you proving that they have acted in bad faith or capriciously, they will defer to what that regulator has done. Yeah, secondly, the issue of access to courts. We need to apply the principle of exhaustive remedies to dealing with issues that, especially matters that affect our critical national infrastructure. You can't just bring a suit to challenge the action of a regulator that oversees a sphere of activity that is very critical to everyone because you are displeased. So you must have gone through the whole log before you institute that suit, right? Then, thirdly, there has to be time into these suits. Fine, we know that the rule here is once you go to court, everybody pauses. We maintain status quo. We need to have fixed timing on how we resolve these matters. That matters that affect this country's critical national infrastructure, treat it like an election petition, because I think it's more important than appointing Jimmy to the House of Assembly, Honorable Jimmy, right? treat it like, let us say the suits must be dispensed with in 90 days or 60 days. Then fourthly, let us do what they do in England, where the rules force people to think twice before you bring actions in court. In that, once you lose, you will pay all my fees. And we saw it recently in the PNID matter where we got £200 million. Once you decide to go to court and you feel that, oh, you and I sitting down to talk is not enough, that we must go to court. If I decide to bring 50 senior advocates, including Professor E.L.R. sitting here to defend me, the minute you lose that matter, you are paying all their fees and what it has cost me. You see, that way, once we start to put that in place, we will start to think twice before we do things and think in the interest of the overall sector, not just one person.
I totally agree with you. Processes are very important. And I think it's also it comes from the fact that from the point that you alluded to earlier, that electricity is not seen as a commodity. It's a commodity that has a price, and it's in a commercial quantity that people should value and pay for it. But I think we're still in an era of looking at electricity as a social good. So there's an entitlement that, this is part of my national cake, as I've heard in so many, conversations. So I think there's also a lot of capacity building or sensitization about how this power market works. And like you rightly articulated it, a customer takes it to court. The judge also is a customer, isn't he? He has problems with electricity, he's not getting it. So perhaps he's looking at it from that standpoint that, I don't have electricity in my house and you have raised my tariffs, why should you do that? So I think some level of education also needs to happen and sensitization across the different segments, the judiciary example. And now, for example, we have the label that is up in arms. Again, that's another conversation for another day. So thank you very much. Let me go to Mr. Akin Femiwa, who is joining us virtually. I don't know if you're there. I would like to, are you there? Mr.
Yes, I am.
Okay.
Thank you.
Excellent. The CEO of Regulator Power PLC. So, I guess, when the privatization took place, available capacity from the several power plants, which one of your power plants is 414 megawatts. It was 2,900 megawatts at the time of privatization. And I recall from the performance agreements, there was a set target, which the BPE referenced as the capacity recovery target of about 4,742 megawatts. So today, according to the BPE, there's been 78% recovery of that capacity. So you started out 2,900. The target is supposed to be 4,700, and today the 7 privatized power plants have achieved 78% capacity recovery, which is a good score. 78 is A. But this has not translated to satisfactory power supply experience for over 10 million registered customers today. So to the majority of people, obviously privatization has failed because they are not seeing the power. And they are wondering what's happening. Why am I paying for darkness, as you must have heard? So in your view, is this an issue of process or implementation thereafter acquisition, the acquisition that happened? Like Commissioner Dafe referenced from what he contributed, I see it more as a process thing, rather than there's a privatization process, so it should have been done in phases, and there's the implementation. What's your view on that?
Thank you very much. First things first, Geregu is operating at 435 megawatts and not 414. And we have actually made 435 megawatts instead of the 414 you mentioned. We are one of the people who have achieved 100% in terms of capacity improved today. But let us look at the process. The privatization process, like Mr. Akpeneye mentioned, was a bit aggressive. The process itself was very transparent. Each preferred bidder met the pre-qualification criteria set by the federal government and the BPE. But the problem we have today wherein it seems that the whole exercise is a failure lies in its implementation. Now, post-privatization, we were meant to operate within the ambit of certain guidelines. And it was meant to be an industry regulated by what we refer to as industry-based contracts. Now, what are those contracts? Those contracts are namely the power purchase agreement, the gas transportation agreement, the gas supply agreement, the grid connection agreement, as well as the vesting contracts which the DISCOs should have given to NBET. Now, the problem we have today is such that none of those agreements are operational and effective. The way they're supposed to work is as follows, and it has to do with every Nigerian and not just the companies who are operating along the power value chain. It's such that if, for example, we generate power upstream as a GENCO, that's as a generating company, for the capacity that I've made available and the power that I've generated, I should have a power purchase agreement from NBET to sort of secure my own investments that I've made since 2013. Now that contract doesn't exist today. The second thing is moving from the PPA. But ahead of the PPA, I'm also supposed to give a gas supply agreement to the gas suppliers who gives me the feedstock to generate power, to the grid. And I'm also supposed to sign a gas supply agreement. Now, those agreements are supposed to act as incentives for them to invest in supplying or providing more gas to the power sector. Now, those agreements are ineffective and are non-operational. Now, we then move to the power, so the PPAs too are not effective and operational. Then we then move to the vesting contracts. Now, the vesting contracts, which the DISCOs are meant to give to NBET, has also not been operational because we do not have the culture, we have not totally imbibed the culture of paying bills. And as such, the DISCOs still have collection losses, and which we refer to as commercial losses, in trying to bridge the entire gap. Now, all those agreements are not operational today. And what does that mean? We've embarked on a very aggressive exercise, and we're supposed to operate within certain guidelines that we're not operating. So what has happened is the entire sector is in a state of dissonance as far as I'm concerned, because while a lot of investments have been made upstream, which is the generation company, which is the GENCOs, what has happened is that the corresponding investments for the expansion in grid capacity and metering, and for also individuals to actually pay their electricity bills have not are not in alignment with the type of investments that we have made upstream. So this dissonance is the main problem where that makes it seem like we do not have a sustainable national electric supply industry as far as we are concerned. But I think these are all teething problems that can be resolved. I think we need to be patient, because if you look at other emerging economies that have embarked on privatization, like Mr. Akpeneye said, everything has to be gradual. And I picked a statement from the Vice President's speech, wherein he said, we need to match commercial viability with social responsibility. And I think that was not taken into full cognizance as at the time of privatization. Now, with the presidential power on initiative, I think a lot of these gaps will be bridged for these agreements to become effective, and as such, we'll have a sustainable power value chain. That's my own opinion about the entire privatization process. Thank you.
Thank you, Mr. Akina Kikemiwa. I guess for the record, I would like to ask that when you started at the start of privatization, your power plant was at 414 megawatts, and today, based on the performance, that has moved to 435 megawatts. Is that correct?
No, that's not correct.
Okay.
When we took over in November 1st, in November 2013, we inherited a nameplate capacity of 414 megawatts, but the available capacity at the time was 135 megawatts. Because the other two turbines were due for a major overhaul. So what we then did was we ramped up capacity by carrying out a major overhaul to bring it from 138 to 414 in the first instance. And then we now did some capacity improvements to take it from 414 to 435. So we moved from 138 to 414, and then from 414 to 435.
That's a remarkable performance there. And we have to say well done to that. And hopefully this will show up in more megawatts to the people. Commissioner, you want to add something?
Yes. I think when Mr. Akinfenwa was talking about the contracts and the hindrances, he forgot to mention a particular one.
Okay.
The final safeguard at the end, last mile safeguard in the vesting contracts between the DISCOs and MBET is that the DISCOs have to put in place a letter of credit, right, that backs what the bills from customers. So the GENCO send an invoice to MBET. MBET sends an invoice, that same invoice to each DISCO. And each DISCO is meant to pay. If you do not pay that invoice, NBET calls on your letter of credit, right? Now, I come back to my dear profession. So I remember being a Part 4 student in Ife with Professor Popola teaching me international trade, what letters of credit meant, and how it was a sacrosanct document in international trade. I resumed as a commissioner in NERC in 2017.
Yeah.
And I found out that this same country, whereby the leading author on letters of credit is a gentleman called Ebenezer Adodo, who was in Ife years before me, wrote a book on that topic. Our courts have said that MBET cannot call on an LC. So you see, it comes back to what I said at the beginning, that we need to address the political economy and the way judicial system. We tend to look at government and we only think of the executive and the president.
Yeah, right.
But so the issue of the letters of credit is a big one, and it comes back to where we are today.
Absolutely, and I think one of the things that Rome wasn't built overnight, as we say. And if I talk about the Tata experience, Tata brought down the losses at 50%, thereabouts, when they privatized, down to a single digit today, over 17 years. It took them 17 years. So in Nigeria, our starting point is same, and we wanted to do that in 5 years. Obviously, that is a very ambitious timeline. So I think the issue of patience is very key from what he said, and the point that in those 17 years, they had invested over $1 billion. So again, capital is king. Now I'll go to Mrs. Folake Soetan, who is representing, who is the CEO of Ikeja, and of course will be speaking from the distribution perspective. I know you are the neck that holds the entire value chain. So you are the face of the people. When anything goes wrong, you are the first person to go down, to be hit down, knocked down. Now, at privatization, like I mentioned, we are 50%. The average ATC and C, I won't talk about ATC and C, we're talking about the aggregate technical, the commercial, which is about theft, and the collection losses is the difference between I bill you and what you pay me. That was at over 50% at starting point, and today we are not so far from that target. We're still there. We should be around 18 to 20% by international standards. We're not there, and customers, over 60% of them are not metered. The commissioner here in Lagos made reference to that in his remarks. And of course, like the CEO of Geribu said, they are not being paid, contracts are not being held, so part of that is what Commissioner Daffy has also mentioned, that this course is supposed to put letter of credits, you've gone to court, what is the problem? So let's hear from you. Thank you.
Good afternoon, everyone. Congratulations on the launch of the Electricity Law Report. I'm actually very excited about that. Well done, very well done. As I listened to Commissioner Daffy, I was smiling because I'm happy that today he was able to at least shed some light on what has happened or what is happening in the sector. And when Gerigu was also speaking, he also kind of painted a picture. But like you said, we as DISCOs are the ones that are facing the customers. And the customers have an expectation from us. What does the customer want? Customer just wants power. And he wants to be sure that when he gets this power, he's paying for what he consumed. The customer is not interested, doesn't know what is ATC and C, what's his business with that, your issues, regulatory issues, he doesn't really care. But let me start with the basics of any business. For any business to be successful, the cost of your service must be lower than your price. Basic, standard. If you want to have a sustainable business that is growing, you cannot have a business that your cost is higher than your price. And if you cannot recover the cost of the product from your price, that business is already dead on arrival, first of all. Commissioner Daffy explained, obviously, why the tariffs obviously could not be increased. And of course, because the tariff could not be increased, the DISCOs had to continue to operate at the level they were operating and with the sort of constraints they had. So from day one, even if the DISCOs collected 100% of the energy that they build, there is no way, they're already short, there's no way they can pay the value chain. And the value chain depends on the DISCO. That's one. Secondly, at the start of privatization, Forex was 158. Today, it's 450. How many price increases have we had? And of course, there's an obligation the DISCOs have to continue to ensure that they can improve the infrastructure. So for us, in Ikeja Electric, which is a subsidiary of Sahara Group, and Sahara Group's vision is to be the provider of choice wherever energy is consumed, and they have built very successful businesses. And our mission simply was to deliver reliable and quality service to our customers, while obviously we're maintaining the highest level of safety and standards. But that has been very difficult for us to deliver in recent times. And I'll start with the state of the infrastructure that we met on ground when we took over in 2013. A lot of the infrastructure at the time obviously were obsolete and needed replacement. But obviously that's our job. That's what we signed up for. There was a base loss study done to determine the at least minimum performance level that is required. But there was obviously a variance with regards what we were being measured with. And a lot of the discos, apart from the acquisition cost or loans that they took, had to raise funds to try and improve this infrastructure so that we can provide that power to our customers. You spoke about ATC&C loss being at 50%. I'm going to just share a few facts here today, at least from Ikeja's perspective. And I'm obviously speaking on behalf of the discos. As of 2014, ATC&C losses in Ikeja Electric was at 40%. Today is at 25%. And it would have even been better if not for the pandemic that happened, whereby we were all affected. So energies were pushed out. In fact, more energies were pushed out because we're trying to ensure we can help the pandemic, and customers were not able to pay. And that is the responsibility. That's on the discos. And of course, the GENCOs expect us to pay for that. That's one. Secondly, as of 2014, the energy uptake has increased by 24%. This is from the disco perspective. That is what the disco is pushing out to the end users. In Ikeja Electric, we have invested over $30 million on advanced metering infrastructure. That's metering itself. And for us to be able to deliver the sort of service that is required, we decided that we were going to go with smart meters. So our infrastructure from the beginning, from a metering perspective, was top-notch and it was expensive. And we kind of sequenced how we did our metering. So instead of starting from the consumers, we started from upstream. That's from the feeder points to all the distribution transformers, ensuring that all the distribution transformers are metered. And if they're metered, you can see it from the office. You can determine what customers are consuming. So this was just a wise way of trying to ensure that the billing that we're giving our customers, is fair. We also have invested about $6.5 million in GIS, that's Geographical Information System. And this is to enable us be able to see all the assets and be able to determine the state of those infrastructure. We spent a lot of money on technology. So today, we are doing electronic billing, the customer CRM tool. And a lot of upgrade has happened with regards to this obsolete infrastructure. And I can say that this is what other discos as well have done in terms of investing in manpower, infrastructure. Now, I say this because there hasn't been a way of recovering that investment that has been done. But you've seen the improvement. And there's no business person or investor that will put money in a business and doesn't have any way of recovering it. Do you get? So the reason I thought is important that I paint this picture is important that people understand some of the constraints that we have. The discos can't actually access funds because the banks are not going to touch you.
But why, when you say the discos can access funds, why is that?
Because I just said to you, acquisition costs, you took a loan. There's equity and you took a loan. The discos, most of the discos have not been able to even pay off that loan. That's the acquisition. Over the last 6 years, you've invested in this same infrastructure, and that's the only way we've had the sort of performance that you've seen. We haven't been able to obviously pay back that investment, and there's no way of seeing how we're going to recoup that. Now, I'm not trying to paint a bad picture here because you heard the VP's speech. You've also heard the HC speech. There have been discussions going on with all the stakeholders on how the discos and the value chain, actually, not just the discos, are going to be in a position whereby they're going to be able to access funds. they're going to be able to improve the investment that they need to ensure people get the power. And so it's not a bad case, but I thought it's important that at least I paint a picture so we have an appreciation of what is actually happening to the guys like us, who are the ones facing the customers. And all these things I've said now is English, is grammar, quite frankly, to the end user, you know.
I was just about to say that you articulated everything, your investments, but at the end of the day, the customer listening to you,
absolutely,
all they're saying is, well,
exactly.
Do I see it, and for how long, and how reliable is it? So we'll hold that thought.
But hold on though. That said, I think it's important that I also say that there is obviously light at the end of the tunnel.
Sure.
So in Ikeja, because we saw this problem, we thought, this thing can work. Yes. So we decided to leverage on the willing buyer, willing seller initiative. And we ring-fenced an area. And what did we do? We put the required investment needed to ensure people have at least minimum of 22 hours. We put in the type of metering that is required to ensure people have the service. And we made those people pay a cost-reflective tariff, which shows that it can work.
Yeah, if you give proper service,
absolutely.
And customers are metered,
yes.
I expect that they want to pay for metered quantity.
And the customers are paying. Yes. And they're getting the service. And I mean, this is Magodo GRA. Sure. So I'm saying that if all the discussions we're having now with all the stakeholders, which is tied to what I've just said, yes, it can work.
Absolutely. I totally agree with you. There's no business that can thrive with price that does not cover your costs.
Yeah.
And starting from what Commissioner Dafe said earlier, they've not been adequate cost recovery because of all the legal issues, which snowballed into a huge tariff shock for today. And, it's hard to swim out of it, but hopefully there's a light in the tunnel. So now let me go to Honorable Folajimi Lai Mohammed. Thank you very much for joining this panel of discussants. In the HC's speech, he made reference to the fact that the law that was passed in 2018 that was supposed to kind of boost embedded power generation was not so successful, from what he said in his speech. Between 2010 and 2015, Lagos State has put in about 5 IPPs, I believe, in Alausa, on the island, Akute, mainland, and peninsula. And the total of that is 47 megawatts. And obviously the idea behind this law was to add to that, increase it, provide power to underserved areas, perhaps communities that are not within the catchment areas of the distribution utilities in Lagos State. Would you, give us some more insight on that? Why didn't that law achieve the objectives? That would be interesting to know.
Thank you very much once again. Before I answer that, I think I just want to make some clarification to Mr. Akbene that I wasn't appointed like he was. I contested an election and I won. Yes, I thought I was the only one who heard the Honorable Commissioner say that the bill was not, what was words, maybe it's good enough, sufficient, or it didn't cover, it wasn't implemented. First and foremost, I want everyone to know that that bill was an executive bill. It was sent to us, and we, to the best of our ability, and I happen to have been chairman, Committee Energy and Mineral Resources at the same time as well, too, when this bill had come to us and it was passed. I think without any fear or favor, I think we should always see government as a continuum. And this goes to my commissioner. When different governments come in, we want to come in with different agendas. We've provided a legal framework. And I think implementation is what is next in terms of the infrastructure that you have on ground. However, I dare say that no other state, apart from Lagos State government, or the Lagos State House of Assembly, has passed such a bill into law. And we need to understand that power is on the concurrent list. And the area at which the state government can intervene in this is only rural areas where it's not connected to the national grid. I believe that's the position. Now, this same bill, at the time he came in with the executive, I remember that the former commissioner made over 100 trips to the NERC. I think at the last few trips towards there, I had to step in as a member of legislature. I remember the other time they were asking, they haven't sent this bill to you people, and you are already following them to go to NERC. Because all we wanted at that time was a letter of no objection, and which was we had to make sure there was proper clarification with respect to the powers and the delineation of powers that were within the federal ambits and within the state ambits. Now, if you read carefully, most of the wordings in the law, you find it assist, liaise with, implement according to, subject to the federal. We had to defer to the powers above. But you see, when you have such a law on the state government level, you would see that it actually boosts, one, confidence of the consumers, number one. Number two, even the discos sit up tight. On Monday, as I have the highest number of petitions in Lagos State, starting from unfair billing, justified billings. So what I do most times is I do a class action. Okay, Ikeja, you have 10 people today. Ikeja, we're spending the day together. And I was actually very impressed when one of the, not because you're here, but conveniently for your lawyer as well too, when there was a petition about energy theft, and the lawyer from Ikeja Distribution quoted the law. He said, Mr. Chairman, this is power theft. According to section this, I said, oh, really? Lagos State, you have started practicing this thing? But when it's convenient for you, you call me and say, no, power is for the federal. You cannot call me, you cannot invite me. But you see, it's a subtle way of putting everyone on their feet. So, yes, it's a legal framework. I would implore the executive, don't forget, most of it was more like it was focused more on embedded power. And we wanted to ring fence certain areas where if you are, Ikeja, not again because she's here. As she said, you have a willing buyer, a willing seller. A willing buyer, a willing seller now. They've ring fenced certain areas. They've put what you call the premium power customers there. They're doing that. And you see, when the customer, with the bill that has been passed into law, there might be certain loopholes that are there, and that is why we are there as members of parliament. When if you feel there's something else, we can come up, put up a stakeholders meeting, report. There's nothing that stops it because change is dynamic. Every single time, different things will come up, and then that's why the bills, the laws that have been passed, we're always ready and available as the people's constituents to listen to them, and then when stakeholders meetings are taken, we take in the notes. We see it from our views, and I put our heads together, and we put it. So to that effect, I will say yes, it's a start. They've mentioned that it's all about patience, and also I would like to implore the executive to see as much as possible how they can implement the legal framework that has been set up. Thank you.
For Lagos State to be able to implement as expected. And in so doing, I believe that the review that the HC referred to is to hopefully make the law more encompassing, reaching where you can do much more than you have there today as embedded generation. So we've talked about generation, and I think it's time to speak, and we've talked about distribution. I think it's time to speak to transmission. So this question is to you, Mr. Malo. There are resounding arguments and debates asserting that the privatization transaction of 2013 is a failure, and calls have even been made to reverse it. In the same breath, there are calls to privatize TCN. Given these conflicting positions and the state of NERC today, is the privatization of TCN feasible? Is that a likely option to be considered by BP or the federal government which you represent?
Thank you very much. Before I go on to TCN, let me just take advantage of this opportunity to address the issue I started on by saying that what was actually lacking was nurturing. And I'm glad that Commissioner Epene actually made reference to that. That aspect of legal nurturing was also not well taken care of. And that was why we had a very deep hole that we needed to fill. There was a nurturing that also was supposed to come from the government side to take care of the social content of the price of power. There were clear calculations in the model, the amount of money that government was going to provide as subsidy over a number of years. Government did not provide that money at the time that they needed to provide. So the commercial framework that will have made the power sector to be viable was not put in place. The nurturing that needed to be done in the area of regulation also was not there. For instance, between 2015 and 2018, where there were supposed to be around 7 tariff reviews, only 1 was done. And therefore, the kind of thing that Foleke talked about, where you needed to have the cost of power, being yes, at the correct level, so that they can get the kind of return that will enable them invest and renew the infrastructure of their networks they could not do. That was another form of nurturing. There was another form of nurturing that was not properly done. Managing the expectations of the stakeholders. The masses expected the kind of massive development that happened in the telecom sector to be also replicated in the power sector. Forgetting that the kind of investments that are required in the power sector were higher and they were of different dimensions. For instance, given that for almost 3 decades, there were no investments in the power sector, these investors needed to come in and renew the infrastructure as well as expand it. Without the commercial framework in place, definitely you do not have the money to make the kind of investment we are talking about. So nurturing the reform, the way it's supposed to perform, we did not do it. So we could not move from the transition market to the real commercial market. Even at the time when we were supposed to be trying to transit from the transition to the commercial market, things were done haphazardly to the extent that we were reversing back to the initial position that we were starting from. And that is why things have not happened the way they were supposed to handle them. Look at the macro issues too. When they began to happen, there was no mechanism to take care of them and make sure that the system can respond to, for instance, changes in foreign exchange level or changes in inflation and so on. And this was supposed to be taken care of by the tariff review. All these things did not happen. That was what I meant by nurturing. We did not nurture the reform, and therefore it could not produce the kind of result that we wanted. However, there were sparks of good performances here and there, just like we had in the generation. We had huge successes. Most of the generation companies actually ramped up capacity to a very appreciable level. In the area of distribution, we are having challenges. Now, let me take on TCN, where it remained a government institution. Of course, we tried management contract that did not work. It did not work because of, again, certain issues that were political, just like it was highlighted earlier, that political issues within the power sector actually tend to be very serious problem in running the power sector. However, it will be very interesting to note that for TCN to remain the way it is, it has some conflict of interest. One, it is a transmitter, and 2, is a system operator. by system operator is supposed to be able to dispatch power from those who are generating power dispassionately based on a merit order. Now, if you are having a merit order that does not reflect the kind of rules that have been set for the power sector, then it means you are not encouraging those who are producing power to produce power the way they are supposed to do so. So you have a situation where TCN drops power where the discos do not want it, and yet they are supposed to collect money from where that place that power has gone to. I give you an example. In Kaduna State, where the area where there is banditry now, or even in Benin Disco, where in the creeks where there are issues, you send power there, and the people cannot go and collect the revenue for the power that you have sent. So it becomes a problem to the discos. These are issues that are being addressed, and we believe that going forward, even TCN will need to be further unbundled into their component parts. The system operator needs to stand on its own as a government institution and serve as an unbiased arbiter that will make sure that power is sent out to consumers on merit order. The transmission component could be unbundled and concessioned based on a configuration that we will work on. Certainly, government is looking at all this, and indeed, the National Council on Privatization, at the appropriate time, will take the steps to make sure that the transmission segment is also concessioned. It will not be privatized. It will be concessioned and operated in such a way that it serves the network properly. Currently, the interventions are trying to make sure that all the points where we have bottlenecks are removed so that we can have some level of efficiency.
Thank you very much. When you talk about concession, which is one mode of introducing private sector participation in transmission, of course there are other modes of doing that. So you have build, operate, and transfer, or build, operate, own, and transfer. There are different models that can be applied. So obviously, I guess there should be like a mix. So you have concession, but also a basis of having private sector coming in to actually invest in building the infrastructure and being able to recover it. Now, that will take me to Commissioner Daffy on tariffs, because this is very important. What is your view on this, private sector participation in transmission? I have come across a number of investors who wouldn't mind investing in transmission development today. If you notice today, most of the funds that go into transmission are from development partners and government budgets. What we'd like to see increasingly is private capital actually going to transmission. Perhaps the unbundling will help. But today, there is no regulatory provision that would give an investor comfort that if I invest in a transmission structure or asset, I will recover my money. Because like I spoke to earlier, we've all spoken about in this panel, the cost reflectivity is an issue. So is there some kind of thoughts around that to have private capital come into transmission development?
Okay. First point. The issue of privatization in the transmission space is something that requires deep thought. In most jurisdictions, because of the national security implications of transmission, it's always held by government. And besides even being held by government, the type of security clearance you would need to play in that space, to work in that space, is at the highest level. Because you hold in your hands the capacity to put an entire nation in darkness, just like that. So what government, I'm not a policymaker, but the thoughts around that, we have to be very mindful of the national security implications. Then secondly, it comes back, we cannot bifurcate transmission from the entire sector. Everybody in the sector gets paid from the bill that you receive at home. So that bill that you receive at home, our customer bill, it takes care of, one, the disco's cost. It takes care of the GENCO's cost. It also takes care of the cost of the transmission provider and the service providers in the sector. If that bill doesn't capture all those costs, there's little we can do to address everybody. Now, anyone who's interested in coming into play at transmission level, it's only when we've reached a stage that the costs are not only reflective, but the TCN cost. What most people will not realize is that because in modeling the tariffs, the TCN tariff was frozen for a long time until the last review, because we see it, TCN was seen as being part of government. So before anyone wants cost, because there's no other way of attracting revenue. The GENCO is not going to send the customer a bill. Sure. The person who is willing power is not going to send the customer a bill. All that comprises the entire sector is built into the bill that Folake's team and the other discos send to the customers. And until that bill is commensurate enough to cover everything we need to do in the sector, I do not see how anyone else is going to come in under any means, either concession or, because people will do a model. I worked with consultants for 11 years of my life. If someone will get an Excel sheet, how am I going to get my money? Absolutely. And if at the end of the day, they cannot see a line of sight on how that money will come back, you can't present that before your board to make an investment decision. Because they'll tell you, we're not the Red Cross, we're not the charity.
Definitely. Thank you, Commissioner Daphne, for that. Before I open up to the floor for questions, I would like to ask this question around state regulatory commissions, and that's to Honorable Falajimi. Lagos State obviously is at the forefront of trying to ensure that the supply, the demand gap is met. I was reading a recent report where it says that at the end of the century, Lagos State population will balloon to over 80 million. Today, we are over 20 million. And I think Hipsy alluded to that fact in his speech. Today in Lagos State, you have 1.6 million registered customers. The peak demand as of 2019, my company actually did the energy demand forecast for most of the distribution business. The peak demand for Lagos was 2,800 megawatts, and the peak supply at the time was 1,900 megawatts. So the net difference really is the gap that needs to be supplied. And this, of course, does not include captive generation. Now, definitely, as the HC referred to, the market is in Lagos. And there's a lot of potential because as the population balloons, demand will rise from economic activities. Now, is this time for consideration for state regulatory commissions that you have now? Is this something that we should be preparing for? Will that help in actually complementing what the federal government is doing at the federal level? What's your take on that? And when you speak, Commissioner Daphne, I would like you to respond to that. I would like to get your point on that, and then we'll open to the floor for questions. Thank you.
Thank you very much. I'm currently acting as the regulation person right now because all the petitions and everything that's wrong in Lagos State right now has to come to the Lagos State House of Assembly because I'm the only bridge between the discos and the consumers and the customers right now. So, yes, it is necessary to have it. But if we go back to the embedded power bill that was passed, there is something which creates for, I'm thinking is a section 27, thereabouts. There's something called the power council. Yes, the power council there is meant to represent what we're asking for right now. And it consists of people from the trade unions to consultative forums to, we've broken down to even heads of different areas. And then we have representatives from the government as well too, which will form this power council. So this particular thing, if implemented, and when it starts to be implemented, you will see that this bill has catered for this area of state regulation thing, which we in the wisdom of the executive at the time, they decided to put it and embed it in the same bill so that it's not looking as those, so it's all encompassed under one bill. And then when issues happen and arise like of that nature, they know that there's a council that would address the particular matter, and then they're able to regulate the complaints of the people, also put the people in order. I mean, most times I would say that I know the limits to which I can invite the discos. I know the limits to which, but of course, they want to be seen to the people too as doing very well. And as someone said there, all they want to know is their light. You know, someone says, "Oh, what was the basis of this billing?" I don't have a meter. We've had situations where someone said he traveled, he wasn't in town, he comes back, he's gone into this bill. It's that bad. So yes, it is, and by the time we get such a forum in Lagos State, it will reduce the workload that I'm doing currently.
Okay, before I respond to that, you spoke about doing the analysis of the power needs of Lagos, and you put it at 2,000 megawatts. 2,000. Okay, 3,000. I'll give you that. You see, please. You see, when you talk about megawatts in isolation, people do not appreciate the cost. There's a plant in this country that is about 450 megawatts. Yeah. And it is costing us $30 million every month to meet up the commitments of that plant. Which state, and I dare say the Honorable Commissioner from Lagos is here, if Lagos can tear a check for the commensurate dollar value of just the generation cost, so multiply, what would it cost us for a 2,000 megawatt or a 3,000 megawatt plant? That is almost what we are consuming as a whole country. And there are issues with payments. So it all comes back to Naira and Kobo. And we cannot hide away from the cost. And we need to develop a path and a strategy on how we can get to affordability. I remember buying a SIM for 50,000 naira in this country. Yes. But today, and we're paying 50 naira per minute. But today, I do not know how much a SIM is. SIMs are free. And I do not know how much my call is. So let's put that at the back of our minds. Well, isn't that because competition has set in? It's not about competition. It's because we have allowed the benefits of investments, and we're now reaping the benefits of skill. Yeah, okay? So coming back to the issue of states, the question you asked. On the 2nd of August, 2017, I received the former governor of Lagos State, and Honorable Folajimi was on that contingent. And we told them that we will support any state's intervention in the power sector within the ambit of the law. And the former commissioner, there's a letter, I was in the presentation somewhere in London, and I saw he presented a letter with my signature on it, whereby we're conveying the approval. NERC sees nothing. Our role, we're not here to regulate darkness. The more we can see that power gets to every nook and cranny of this country, from Sokoto to Mubi to Calabar to Ekpe, if we can get power, we've succeeded. So it's not about, there's no tough competition here. It's not about tough. And government exists for the welfare and security of its people. So whatever vehicle, whatever means we can use to achieve the means of government is fine. But we need to bear in mind that for an industry to grow, we must invest in that industry.
Thank you very much, Rafi. And we have actually exhausted our time, and we're talking about power sector today. We can be here till midnight because there's just so much to discuss. Very interesting, great insight from the panelists. So before the MC comes up, I would like to have 10 seconds from each panelist just to close. What is the way forward? What are those critical things? One thing each person. I'd like to start with the CEO of Group. Please give us one thing that we should hang on to tonight as the way forward to progress things post-privatization. We want it to work from all the contributions. Obviously, there's light, there's hope in the thought, there's hope that things will progress and life will get better. So let's hear from you. 10 seconds.
Okay, thank you very much. For me, as an industry captain, I have adopted the approach of collaboration. One thing that is peculiar to this industry is that there's a lot of blame game. The discos will blame the gencos, the transmission company will blame the gencos and all of that. But at the end of the day, it doesn't deliver the absolute benefits to the end user. And we're all complaining about what has not been done, the agreements that have not been signed, things that have not been put in place, stranded power, and all of that. And at the end of the day, we need to move forward. So for me, in order to realize the full benefits of privatization, collaboration amongst every player is very, very important. Government should see the private sector as trusted parties. Private sector should also provide solutions that are to the benefit of ultimately to the benefit of Nigerians, to the federal government. Let us all make the presidential power initiative work so that we can have a sustainable Nigeria electricity supply industry. That's my own view. Thank you.
Thank you very much, CEO Gegu. Falenge, please, could you make your closing remarks on the way forward?
All right. I'm an optimist by nature, and that's the only way I could have survived. Yes. So clearly, there's a lot of work to be done. And I think that the MD of Kirigu was very correct in terms of we have to stop the blaming game. And we need to work as a team and collaborate, because at the end of the day, the singular most important person here is the customer. And all the customer wants is light. And I believe that together, looking at everybody here, my panelists, my regulator, together we can make this work. My HC has been very, very collaborative with the Ikeja Disco. We're doing a lot together. So thank you very much. So together, I'm very positive and I'm very hopeful that we're going to achieve together.
Excellent.
All right.
Okay. Have I brought this despair? So I would see it that, and I would use your analogy of the central bank. I don't think anyone here, except maybe Professor Elias, can name 5 CBN governors before Soludo. And that was the turning point of when the the CBN really became an institution, whereby before Abacha, we would have cycles of failed bank tribunals where bank MDs were hauled before special tribunals and tried for mismanaging the banks. And we don't have that anymore, to the extent that we've had recessions, near recessions, and our banks have still stood. Why? Because we've built a very strong regulatory institution in the central bank on the back of enabling law that enables the CBN do what it must do. We need to replicate that in the power sector. And the Electric Power Sector Reform Act was a good piece of legislation for achieving a privatization, but not very good for regulating a power sector. And we've seen the gaps over these 16 years we've run the Act, and we need a piece of legislation that replicates what you have for the CBN in the power sector, and we also need a buying of the political economy for the regulation, for regulating the power sector, like we had when NCC imposed that fine on MTN. MTN went from pillar to post. They brought in Eric Holder, but as a country, the political economy said, no, you have breached a regulatory framework. You must pay that fine. And today, if the NCC sneezes, every licensee catches pneumonia. So once you do that, I think a lot of the issues we find in the sector, you start to build in confidence because people know how to, okay, this is the regulator, these are the rules that bind the regulator, and these are the rules in itself. So people start to see, and you now start to have, because I think we have the largest power industry in Africa. And there's no bigger opportunity anywhere. There's no part in Africa today that needs 5 million meters today. But we need that in Nigeria. So once we put those rules in place and there's certainty, investment follows certainty.
Absolutely. Thank you very much. Thank you. Mr. Bano, 10 seconds, please. Closing remarks.
Okay. Okay.
No, I want to give you the last word as our host. So,
Thank you very much. I want us to understand something. Nigeria is a very attractive power market. I got this information from some of the multinational institutions that we've interacted with. They find it, that is why they don't mind providing us with resources to make sure that the market works. The next telecoms miracle will be in the power sector, and it's about to happen because of the enormous efforts that have gone into putting back the power sector where it's supposed to be. The amount of efforts, the amount of energy that has gone into this sector in the past few years is far, far, far greater than any time before. The interventions are beginning to materialize. Some of the things that we are beginning to see now are the outcome of all those meetings that have taken place at the back. For instance, the tariff review that has taken place. We plead that let Nigerians be patient, just like Akin said, let's be patient. This thing is going to work, but we need a lot of patience so that the kind of investments we need in the sector can come. The government has decided to intervene, and they are intervening in a very peculiar way that will produce results. It is no more the kind of intervention that is being affected by politics. It is the kind of intervention that is done by the technocrats so that you have, is dependent on performance. Wherever resources will go to, it will be based on performance. And I think that's the kind of thing that we need in the power sector. I totally agree with Commissioner Daffey that we need a very strong regulator. We need to have the kind of regulator that can actually make the sector to work like a commercial market. And I also believe with NERC as the central referee, we can have the state regulators as the linesmen that can always draw the attention of the central referee to make sure things are done the way they are supposed to be done. Thank you very much.
Thank you very much. So we'll give Honorable Falajimi the last words. That's why I wanted to save the best for the last.
Thank you very much.
Thank you very much.
Way forward, regular sitting allowance. On a more serious note, better collaboration, long-term local currency funding, and also the regulation of certain sectors in the power sector. Thank you.
Thank you very, very much. So the wrap up today from everything that has been said, as a way forward, collaboration is key. Everybody's hands must be on deck. No fighting, no bickering, no passing the blame. We need to collaborate. Nurturing of the reform structure, very important. Our legal system, strengthening the regulator is very important. Looking at the political economy is very important. And most important out of all this is to have a performance-based driven industry. Everything should be performance-based. People should pay for what they are getting, and people should be compensated for good performance. And then lastly, long-term local financing is so important. I think that is critical to reduce the cost of financing locally and to encourage more investment in this sector. So on that note, I want to thank you. Thanks for the opportunity to be the moderator to this very astute panelists tonight. Thanks for the audience for your time in listening, and thanks Wale and the entire team for this privilege to come and be part of this historic moment of the electricity law report that has been that will be launched. Thank you very much, and have a good evening.
Thank you very much to our panel and to our moderator. Can we give them another round of applause, please? As they take their seats, I will just call out their names just to acknowledge them one more time. Mr. Yunana Jackdale Malo, thank you for being here, sir. Director, Energy Department, Bureau of Public Enterprises. Mr. Dafe Akbeneye, Honorable Commissioner of Legal, Licensing and Compliance Division of NERC. Thank you so much for being here. Mrs. Folake Shoeton, CEO, Ikeja Disco. Mr. Akinfemiwa joining us virtually, Managing Director, Gerugu Power PLC. And last but certainly not least, Honorable Falajimi Lai Mohammed, Chairman, Lagos State House Committee on Energy. And of course, our very able moderator, Ms. Rahila Thomas, Director, EMRC, Nigeria. Thank you so much. We're going to move the program along just very quickly. We want to thank you for being a wonderful audience. We know we've taken much of your time, and I think it's important to note that we've had about 200 people on Zoom. So can we acknowledge the people who have joined us on Zoom as well? It's not easy sitting through a virtual session, but they've stuck with it, so we say thank you very much. And at this time, we are going to officially present to you the electricity law reports, and I'm going to call on Professor Gbolahan Elias, SAN. He'll be representing Mr. Aderemi Makonjola, Chairman, COSG PLC. Please welcome him as he comes, and I'm just going to read his profile very quickly as he makes his way. Professor Gbolahan Elias, SAN, was called to the Nigerian bar in 1981 and the New York bar in 1990, and has been a senior advocate of Nigeria since 2005. He had been an associate at Kraveth, Swain & Moore, a preeminent New York law firm, in late 1989 and early 1993. Now, prior to that, he studied law at Oxford University in the UK with laurels, and he was a junior research fellow at Oxford University's Merton College, from 1986 to 1989, and he graduated with a doctorate degree in 1989 and published the book Explaining Constructive Trust in 1990. He has been a visiting professor of law at Babcock University here in Nigeria since 2013, and he is currently the Pro-Chancellor Chairman, Governing Council, Lagos State University. Ladies and gentlemen, please join me to welcome Professor Gbolahan Elias, SAN.
Good evening, and thank you very much for the round of applause. I should like to start by making a small correction. I'm not the Pro-Chancellor or the Chairman of the Governing Council at LASU. I'm just the Chancellor of LASU, which means basically that all I get to do is wear a very fancy gown at the convocation, and I don't get to do much else. But thank you very much for the introduction. I'm very pleased to be here. I'm sure that at the very least I would have helped with launching the book. The chief editor is very well known to me, and I commend him for this excellent initiative. But it's my big brother, Mr. Makonjola, that has primarily asked me to come and represent him here, and I do so very gladly. He's been very good to me over the years, and it's someone I like and respect very much. I believe he has also launched the book already. I don't know if the editor can confirm that. He sent me a WhatsApp message, so I'll leave you to announce the details if that is in order, but he has launched it in a very generous way. That is very praiseworthy. I will launch it to the extent of my own small pocket too, in due course, but I have to consult my accountant first. So I will not be announcing a number, at least not at this stage. I would like to thank the members of the panel very much. Great insights. In the long term, I remain as optimistic about the industry as I've been for the past 20 years or so that I've been involved in the legal side of it. I think Commissioner Akwede is very right. The biggest key to unlocking the door is to have people pay for what they're enjoying. And all of these games, people suing to stop changes in the tariff, etc., I've always found very, very irritating. I'm wondering whether somebody is just trying to sabotage the system rather than letting us have the progress that we all need very much. But great insights all around. I didn't know that my learned brother, the honorable member of the State Assembly, was such an expert on power. I know him as somebody in the same line of business as myself, and he's been very close to my brother too. I didn't know he was an expert on power. I think I'm meeting the CEO of Ikeja Disco for the first time. Our guy in Girigu had met many years ago in a different context when he was still in 40. He wasn't a power man then. But as I said, great insights all around. I hope everybody has benefited from them. And I would also like to encourage the organizers maybe to put it in permanent form. There will be people who are interested who are not able to come here today and can still benefit from it. But to refocus on the law report that is being launched today. I had an experience many years ago. I think it would be something like 28 years ago. That was one of my great aha moments as a practitioner. I was involved in a case that involved securities fraud. That's fraud in issuing shares, bonds, and so forth in the US at the time. And it all turned on the fact that somebody had made a misrepresentation in a prospectus. And the prospectus was about a decision by FERC, the American equivalent of NERC, on rate regulation. I had no clue whatsoever about electric power regulation at the time. And I was surprised that there was actually somebody, one of the lawyers involved in this case that I've mentioned in the US, who did nothing else. It was his 24-hour job to be arguing about rate regulation. That's before FERC. They set a new rate. Routinely, all of the people in the system protest. the GenCode protests, the DISCOS protests. He goes through the system, and that's all he did, just about rate regulation. Super expert. He knew everything that had happened for the past 30 years and more. And it was my first close encounter with somebody who was very, very specialized in that kind of narrow way. Some of us may say we are experts in energy, which probably includes oil and gas. Even for an expert in electricity, there are many other things apart from rate regulation. This is the only thing that guy did. But it also meant that the system was very efficient. People didn't just start writing petitions in the newspapers when they're upset about it. You challenge it on a technical basis, and you go through it on a technical basis. The significance of the report we are launching today is that it is like a first step on that path. Without having specialized law reports, you can't have the kind of minute specialization that we need in the long run if this sector is going to go higher. So I commend the people behind the publication very much for that, and I hope you reach out to more fora. Somebody has mentioned the Lagos State High Court. There are probably many cases in arbitration, which ideally should also be there to enlighten everybody. The extent to which those can be publicized, I don't know. I know my brother E.L.R is involved in a very big one somewhere. But I hope the publication will go from strength to strength, and that you'll have a digital one very soon. Nobody does electronic anymore. You do? Okay, very good. Okay, so I think it's time to shut up, but it's a great honor to be here. I think it's a very commendable development, and I hope both the industry and this particular publication will do excellent work in the years ahead. Thank you very much. Thanks also from Mr. Makonjola. He really he regrets not being able to be here, but he's totally behind this effort.
So we're not quite done yet. I'm going to ask you to please take a step to the actual launch of the reports, as I call on the editor-in-chief of this law report, Mr. Wale Irokosu, to join us. And I'm also going to call on Chief Bolaji Ayorinde, SAN OFR, to please join us as well as we officially launch. And then I'm also going to call on any of the members of the editorial board who are present to please join us as well at what we'll call the launch table. So if any of the members of the board are here, editorial team. I do have to mention at this point that Mr. Makonjola has launched the book with 2 million naira. So can we give him a round of applause, please? And while we get situated, please permit me to acknowledge the presence, I believe he's still online, of Mr. Adebola Ayorinde, the Director, Northwest Distribution, Construction and Maintenance of Southern California Edison, one of the biggest energy companies in the world. Can we please acknowledge him with a round of applause? He's joined us online, and also Mr. George Itomi, Principal Partner, George Itomi & Co. So thank you so much for joining us online. Okay. Please bear in mind that you'll be receiving pledge cards as the night progresses if you want to pledge tonight. The book will also be available outside. You can pay via POS transfers and cash. So I'm going to let Professor Elias just say a few words and then officially launch the reports.
Impactful book. Please support it generously. Thank you.
Thank you very much. I think we can give them another round of applause. We can now say that it's officially launched, the Electricity Law Reports. Congratulations to the entire team on a job well done. And just to wrap it up, because we know time is far spent, I'm going to call on Chief Bolaji Ayorinde, SAN OFR, once again to please come for the vote of thanks. Chairman, Editorial Board, Electricity Law Reports. Please give him a round of applause as he comes.
Let me say that it is always very scary to speak shortly after Professor Elias. So I would first of all adopt everything he has said. He has helped in thanking all the panelists, and also Ms. Rahila Thomas also did a great job in moderating and thanking the panelists on our behalf. On behalf of the members of the editorial board, let me start by thanking His Excellency the Professor Yemi Oshibajo, Senior Advocate of Nigeria, GCON, the Vice President of the Federal Republic of Nigeria, as represented by Mr. Alex Oko, the DG BPE. We thank His Excellency for finding the time and the grace to be part of this program. Let me thank my learned friend, Mr. Kemi Pinero, Senior Advocate of Nigeria. We would have loved to be here. We spoke yesterday. He's still unable to find his way back from New York, but he was ably represented. Kemi is a very special person. We are colleagues. We have this little group, and they refer to me as their leader. When we have our meetings, they say, "Leader, please sit down." They deliberate, they take a decision, then they say, "Leader, go and announce it." It's a very special group. I thank my learned friend, the Commissioner for Legal, Mr. Dafe Akbeneye, for his insights, very brilliant. And I do also appreciate his frustrations at some of the legal decisions that seem to hold down the industry. And well, in my own special industry, which is the dispute industry, it works both ways sometimes. I would also encourage NERC to be to get more powers, but to be also very open in coming to decisions. I think there should be a lot of publicity about steps to be taken when there's going to be a tariff increase, so that we just don't read it on the front page of This Day that power to now cost this. And you know, so many people are itching for litigation. They will go after that. So both ways, the industry practitioners should also try to be more forthcoming, more open in their deliberations. And we hope that there will be new laws coming to my brother Folaji Milai Mohammed, Honorable. Let us encourage more legislation, giving more powers to the regulatory bodies, and also having the regulatory bodies have strong administrative tribunals where disputes can be taken up, and industry minute experts, legal experts, can play in those tribunals. Like Professor Elias said, it was in a case, the man, he met counsel who had nothing he was doing for 30 years, but cases on tariff. That is where we should be working towards, so that the cases concerning the industry get dealt with at that expert level. And you are not throwing a case about electricity and energy before a judge that has been doing land law cases for the past 30 years. So thank you very much, Folajimi. Thank you, Mr. Akifemwa, who joined us virtually. Mrs. Shweton. Yes, and also thank you very much, the Honorable Commissioner for Energy and Mineral Resources, Lagos State, Mr. Odushote. Thank you for your insights. One more thing, and this may not be on behalf of the editorial board, but as I speak as somebody who is also concerned and passionate about Nigeria. I think we have also a structural problem. And there's a lot of talk about restructuring. The energy that we have used here today, can you imagine that energy being used at local levels? If somebody has to travel and fly for 100 hours to Abuja to get a no objection letter, we should think. Thank you very much, everybody, for coming.
Thank you very much, Chief Balaji Ayanride, SAN OFR, Chairman, Editorial Board, Electricity Law Reports. Thank you very much, sir. And we have come to the end of this session. Thank you so much to everyone who took out the time to be here. We celebrate you. We applaud you for joining us for this launch. And we ask that you please support. There's so many ways to support. You can pre-order outside this door. You can make payments outside the door. You can actually get your email taken so we can reach you for more information on how you can get bulk orders as well. But please, please support and spread the word so that we can get this far wide as it is for everyone. Thank you so much. Have a wonderful evening. We do have photographs that we would like to take, so I'm just going to call out the order of photographs. If we could just get a little bit more of your time before we wrap it up today, but we have officially wrapped up the session. I'm going to call on all our keynote speakers to please come to the stage for photographs.